Good afternoon. My name is Ruth Kraft. I'm the chair of the Employment Law Department at the law firm of Vigorito, Barker, Patterson, Nichols, and Porter in New York. We have offices in New York, New Jersey, Connecticut, and we're about to open one in Fort Myers, Florida. So a very growing, young, wonderful law firm. And I have spoken at the NAMFS conference previously in Denver, had a wonderful time meeting people in your industry. Unfortunately, this year's conference coincided with a vacation that my husband and I booked 2 years ago. So I won't be able to be with you in person, but I thought that there was a subject that's of a certain degree of complexity, but also tremendously compelling, that was worth creating this space, this webinar for you on. And that is the issue of non-compete and non-solicit provisions and agreements. What makes this area of law different from the other areas I've lectured to you on is, in misclassification, we certainly can have situations in which courts in different states use slightly different standards as to what constitutes an independent contractor versus an employee. But we basically have 3 or 4 rubrics in place throughout the states that are applied with relative consistency. We're seeing, despite the standards, the case law appears to get more and more consistent, with the exception of the southern states, which, thank goodness, somewhere in this country, there are people who are pro-business, which is a very nice thing. But non-competes are a completely different animal. I have a list, and I'm just going to hold it up for you. This is a list, and it's many pages long, state by state, as to whether states enforce non-competes, what are the standards they use in defining what is a protectable or legitimate business interest of an employer or any other kind of business, the standards, whether there are exemptions. In some states, the non-competes are legal, but they don't apply to doctors and dentists. Lawyers have no non-competes. It's actually, the law profession takes care of itself. So if I move from firm to firm, and some of you know me from my old firm, my clients can come along with me. I can invite other people to join me. But that's unique to the legal profession in New York. And then we have a very important set of issues that I'm going to go into in detail: consideration, reformation, and enforceability if you fire somebody without good cause. And the standards are all over the place. Now, why is it so important, and why did I decide this was the topic I wanted to speak to you about? Because I represent quite a few regionals, and obviously, by virtue of the fact that they're regionals, they operate in multiple jurisdictions. Some of them operate, scattered throughout the United States, Puerto Rico and Hawaii. Other people operate in contiguous states. So if you are in California, for example, but you happen to also operate in Arizona, you're going to find 2 very different types of laws that are applicable. And what that's going to mean is that one contract will not serve all. Typically, the non-compete is built into our standard agreements, the agreements that the nationals provide to the regionals, and so on down the line. Sometimes the non-compete is broken out as a separate document. If you have different states with different rules, typically I might make the non-compete clause an exhibit or an attachment to a major contract, and then have that added in state by state to protect your interests. Because if you use an agreement that is unenforceable in a particular jurisdiction, what you're going to find is that if you're actually fighting about a completely different provision, the courts will look at that, the existence of that non-compete, and they will not be impressed with you. So it's a very, very delicate balancing act. It generates paper, it generates legal fees, and it is frankly a pain. All of these things impose greater and greater burdens on how you do business. I am aware that in your industry that there are certainly situations in which individuals who operate on the local level to fulfill contracts that the regional has with the national are not below reaching out to that national and saying, I could do it for less money. And so the regionals certainly have an interest to protect in all of this. The nationals can find themselves in a situation where by accepting an offer from a local, they can be exposing themselves as a third-party beneficiary to litigation brought by the regional. And that is something that is an important point to make, because when somebody breaches a non-compete agreement, if I look at that local and I want to sue him for breach, does he have assets? Because honestly, I don't let my clients sue somebody who doesn't have access. I may write a nasty letter, but if you're going to sue someone and get nothing in return, that's a costly endeavor to have a Pyrrhic victory. But often in those situations, I may begin with a letter to the national to say, please be advised that the local, in trying to contract with you, is in violation of an agreement, a non-solicit or a non-compete. And you should be aware, because as the third-party beneficiary, you may be exposing yourselves to liability, and you may not have even known that this provision exists, so I'm taking this opportunity to be an educator. And then that entity can decide whether they want to take that risk or walk away. And since typically in your contracts, it does not guarantee a certain amount of work, it is possible for that relationship to then die out to the advantage of the regional. It is a fascinating subject. So, we see it in the sale of a business to make sure that a purchaser of a business doesn't find himself competing with the prior owner just coincidentally who decided to sell but then compete. We also classically see non-competes in agreements between a company and its employees. So generally in that situation, the non-compete is used to prevent an employee who has left employment, whether voluntary or involuntary, in other words, quit or fired, from working for the competitor or opening up his own business in competition with the former employer. And also one area which you do not see in your industry, but frankly I could see the industry going in this direction, is in franchise agreements. It is very common in a franchise to limit the territory of the franchisee and to say you can solicit and do business in a particular geographical zone, but you can't go outside that zone to the next county or the next state because there's another franchisee who got an exclusive for it. So non-competes historically are enforceable if they are reasonable. And of course, what does reasonable mean? It's whatever a judge or a jury decides it means. I try hard not to use the word reasonable in my contracts. My clients know that the reason I don't like it is because then someone has to adjudicate what it truly means. And you and I could have very different interpretations of reasonableness and fairness, and we have the right to do that, but I prefer to spell it out in great detail. We are also seeing trends to revoke non-competes, to say that they're not legal, in a variety of jurisdictions. It seems to be the more modern view to say, why can't everybody compete with everybody else? So it has an antitrust flavor to it. And you obviously, if you watch the news, you've heard about Amazon and Google and Facebook, being oligopolies and potentially monopolistic, and that's where that sentiment comes from. So the goal for an employer is to protect his competitive business interests and to prevent the employee from engaging in a line of employment, a line of business that's comparable. And the keys are generally that the covenant has to be reasonable as to three things. 1, the length of time. 2, the geography. And 3, the type of line of business that is involved. If it is unreasonable, then what happens? Well, it depends on the state. My favorite example has always been New Jersey. Until last year in New Jersey, if any item in the non-compete agreement was overbroad, the courts did not have the right, by law, to blue pencil or edit the document. The document would fail, and it would fail in its entirety. It would just be torn up by the court, and now you've created a document to try to prevent harm to your business. And if the former employee shows it to a lawyer who says, oh my God, this violated New Jersey law, you can ignore it. If you get into litigation about it, the courts would not have upheld it at all. So it was worse than nothing, frankly. New York, on the other hand, does allow modification of the documents, and the standard forms that you will see in non-competes and non-solicits will say if any portion of this is deemed invalid, the rest of it stays in effect. Or if any part of it is deemed invalid, the court may have the opportunity to modify and lower the covenants such that they would be legal. So that's an important thing to know, because what we have going in New York is that there are a multitude of businesses that cross over the Hudson River. I have a client who does business in both, and they asked for a non-compete, and I said, well, we have a little problem, because what may pass muster in New York will get you torn up potentially in New Jersey. So, and you have the same people in both sides. It wasn't as though we had a set number of workers in New Jersey and a different group doing New York. They were all going across the bridge and through the tunnels on a daily basis. Now the laws have been aligned between the two states. So now in New Jersey, if a covenant is overbroad, it can be modified by the courts to make it legal. Now I keep saying, just in the last few minutes with you, employer and employee, but covenants can also apply between contractors and their B2B relationships. So I might make an agreement with a contractor saying, this is your territory, but you can't compete with me in the territory, or you can't compete in a contiguous area of X miles. How are we going to know whether it's enforceable? We look to the specifics of the business and the interest to be protected. We look, for example, we'll look at how many other comparable businesses are operating in the jurisdiction. If you already have 10 competitors, what's one more? If you don't have any competitors, then one can understand that the value of the covenant to you is going to be very, very significant. So we apply the law in different states in different ways. In some states, we use the common law, and that means the existing case law. In other states, there is statutory mandates. The most famous statutory mandate is that of the Republic of California. And in California, since the 1870s, non-compete agreements have been invalid. They're completely illegal in the state. They are not enforceable whatsoever. It's amazing. I think even though this predates the gold rush by a little bit, I think it reflected the pioneer nature of that state and the desire to encourage competition rather than to limit it. And certainly once the gold rush started, imagine if you panned gold for somebody one day and they asked you to sign an agreement that you can't pan for anybody else ever, ever, ever. That would seem to be a problematic thing, and it would stifle growth of the state and its economy. And California has adhered to this for 100 and almost 150 years. So anyone who does business in California has to be very aware of this. Generally, the courts do not want a business or an employer to impose, through the covenant not to compete, greater restrictions that are really necessary to protect the legitimate business interests at hand. So if you were to put, for example, a clause saying, a general clause saying you can't work at all in this jurisdiction, not just in field services. There are a lot of problems to that. We also we have to look at what your particular field services company does. If you're doing remediation and you don't do inspections, but you try to have a non-compete as to inspections, it probably would be denied because it's not part of the scope of your business. If nothing can be disclosed and you label every single item as confidential information, frankly, the courts are going to say, it's not confidential, I can find it on the internet. that's not going to be protected. What is truly confidential? There's one thing I know that is truly confidential, and believe it or not, it is not the formula for the atom bomb. Apparently, that can be found on the internet in a multitude of places, as well as other explosive devices. The best example of a truly confidential item is the formula for Coca-Cola. The formula for Coca-Cola is only known to 3 living people at a time, and I'm sure that if any one of them disclosed it, they may not be long for this earth. It's located in safe, within a safe, within a safe. That is true confidential information. General business processes, how to fill out an Excel spreadsheet, basic payroll information, that's not confidential information. It really isn't. It's not unique. It's not special at all. Client lists. A client list could be deemed to be confidential if you don't throw it around. If you put your client list out on your website to show, look who we serve, and I'm talking now to the national. So the national lists all the banks with which they have affiliations. That's no longer confidential. It's public. It's in the public domain. Another thing that's very interesting is that the courts have concern about covenants that would preclude somebody from making a living altogether, or a situation in which an individual would have to move away, tear his family away from the location in order to make a living. Certainly, the longer the covenant, the more suspect it becomes. Business processes, business negotiations, business relationships change. In technology, if any of you are in the technology side of the industry, today's technology can be passé 6 months from now. So if somebody has that information available to them, it's useless. You've already moved on to much more highly technological products and references, so that doesn't become as important. And then we also look at something important to me as a lawyer, which are the consequences. What if you breach a non-compete? What are the consequences? Do you have to pay back money? If somebody puts a non-compete clause and it says if you breach this in any way, that your damages will be liquidated, in other words, preset at $1 million, how much did the individual make serving as a contractor for you? Never more than $20,000 a year. That $1 million is extreme. It's not justified. So even though you can make up a contract that says anything, that goes too far. And then we have to look at what's the real competitive business interest at stake. Is the other company or the employee going somewhere else posing a legitimate risk of a legitimate risk to your business? For example, what if you prohibit an individual who's a field inspector from ever working for any other field inspection company for 2 years? Well, we have to know more about the 2 years, but what if that person was an inspector for you, decides that she doesn't really like being outside, doesn't like barking dogs, has allergies to everything in the air, goes to work for another field services company as the bookkeeper or the secretary or the receptionist? That, in many states, would be permitted because there is no indication that whatever knowledge she's gained being out in the field is relevant to the new position. So courts can limit the covenants. They're not necessarily required to do so in many states. In many states, they can just declare them to be unenforceable. Everything will vary by the industry and by the case law applicable to the industry. The narrower the covenant, the better written it is, the more likely it is to be enforced, except in a state like California, which rejects it altogether. There is typically, there is no statute. It's very rare to see a statute say the covenant is invalid if it's for more than 1 year, for example. Some of the newer states, yes, but in most of the states, you don't see that in the law. But know that the case law will advise us as to whether, I have to keep turning myself back on or I get a black screen, as to whether it will be permissible. What if covenant says You can't engage in field services work anywhere in the United States. After all, we've got the same nationals. A lot of regionals are all over the place. I think that goes too far, seriously. And I also think it matters whether you were an employee out in the field or whether you were a contractor with higher capabilities. We know that somebody who's going out and doing field inspections as a part-time job is not likely to be very much of a threat to you up the food chain, but someone who sets up his own business and has detailed knowledge of the industry practices, contracting, all the elements that go into running a business is more likely to be a threat. And certainly the fact that we don't have consistency here makes it difficult, because both sides must wonder now, where is the line? What will cross the line? What will get me sued? What will make me want to sue? And those are not easy answers. Those cases have to be answered case by case, individual by individual. And all of the facts become important. So earlier this year, I was involved in a multi-state case, not in your industry, involving the sale of, I believe it was dental appliances. In other words, the molds, various other dental supplies. And a young woman in Buffalo went to work for this company, and she worked for them for 14 years, a long time. She worked in Buffalo, she learned the industry, and they were so impressed with her that a few years later they offered her a territory. She moved to Minnesota, and she began to sell on the road to dental service providers throughout the state. And after 14 years of doing this, a competing company approached her, and they made her a much better offer. And so she left. She told the old employer that she was going to be leaving, that she wanted to take on some new challenges, and she left to go to work for the other company. The day before she left, she was very busy downloading her contact lists, her emails, and a whole bunch of other data, and printing them out. And because her printer and her computer belonged to the original employer, the employee has no expectation or right of privacy. And the employer checked its records, and they were able to determine through forensics exactly what she had printed out, pricing sheets. So what did they do? They sued her and the new employer, and they sued in Buffalo, New York. Because, hey, if you're suing, why not pick the place that's most convenient to you and least convenient to the defendants? Both of the corporations involved are multi-million-dollar enterprises. They could all afford lawyers. So they didn't have the situation in which somebody was really going to be put out. The only one who wouldn't have had resources, frankly, is the defendant, the individual defendant, who's now in her mid to late 30s. And basically her current employer hired a separate lawyer for her. The Buffalo company sought a restraining order to prevent her from selling whatsoever in Minnesota. The defense said, wait a minute, she does sell some different products, and she's also reaching out and selling to clients who weren't your clients ever. Okay, in other words, she's not going after her existing clients, even though I suspect that ultimately they might come to her, or the covenant will expire and then she will solicit them. But she was being smart about it, except it's not smart to think that you can download stuff off the employer's computer and not have the employer know about it, or have somebody like me tell the employer how they better find it. And so a temporary restraining order was sought. Federal judges do not like temporary restraining orders. It makes them policemen, and they don't appreciate that. And what happened next was that the new company said, look, we haven't done anything wrong. We have no documentation indicating that we encouraged her to do this, that we purposely hired her to do this. And they were removed from the suit pretty quickly. And then they are paying for this employee's defense. And she is conducting business with the third parties who are not associated in the meantime. I will tell you that the ramp up to that 1 week, was litigation 24/7. That was not an inexpensive thing to do. Interestingly, that employer in Buffalo, I have to tell you, has sued others. One of the first things I do if I think there might be a lawsuit is I go on the computer and I go onto the federal court system's web page. Not all the states are web accessible, or if they are, you can't read the pleadings, but in federal court everything is an open system. And I discovered that that company had sued other people and other entities whenever an employee left. They basically were bullies, and they had done it too much. And I think that's also very important. You have to pick your opportunities, because when a federal judge realizes that a company sues every single person who leaves and pulls out the same exact non-compete agreement, whether they are a really low-level worker or it's your CFO, the courts do not appreciate that. You know, one size does not fit all. There is no reason for the janitor to be asked to sign a non-compete. Have I seen non-competes for janitors? Yes, I have. Is it appropriate to have a secretary, a receptionist sign a non-compete? I've seen that too. So I think you have to be very strategic in who signs these things, who you require to sign them, and under what circumstances. It is the interesting thing when someone goes to work somewhere else is that now you have a third party who can be brought into the litigation, as I mentioned before. And generally, before I sue, I send a letter, a demand letter. And by the way, were you aware of the non-compete, which is attached? And sometimes what will happen is that that new employer will say, I don't need this aggravation in my life. I'm not going there, and they can withdraw a job offer. I would encourage anybody who makes an offer to somebody significant in their business to say, to ask in the interview, are you bound by any non-competes? Yes. What did it say? You know, I don't remember. The answer is, I'm not going to make you an offer until you produce the document so that I can read it or my attorney can read it and know that this is safe for me, because I do not need to be in this situation. We actually had a case earlier this year in which the potential employee produced the non-compete, and we learned that the former employer was highly litigious. We thought we still could make her an offer with some limitations, and when she became aware of the circumstances, I explained the non-compete to her and what it meant. She said, I don't want to cause trouble for anybody, and I'm going to withdraw my name from consideration. And my client, even though she would have been a very valuable employee, breathed a sigh of relief, because the last thing she needed was litigation in another state. And interestingly enough, that employer, the original employer, felt guilty for downsizing and then offered the employee a position in a different company, which he happened to own. So it all ended well and with minimal legal intervention, which is always the best thing. I always say that litigation indicates the complete breakdown of human relationships, and so here was a way that we had a document, we reviewed it, we interacted with the potential employee, and were able to resolve something. Now, a very interesting topic, consideration. I am now taking you to literally the first week of law school, contracts 1. A contract, to be enforceable between two parties, involves the mutual exchange of consideration. Consideration means usually services on one side or goods on one side and money on the other side. So what happens if there is a non-compete? Do you need consideration for the non-compete to be enforceable? This will vary state by state, and it's very important. Let's say you have an employees for the last 5 years, and suddenly you listen to me and decide, I really should have a non-compete. It'll protect me. I have the sense that, you know, the ground is shifting under me in this industry. Let me have a lawyer write one. In many states, if you do not pay something in return for the non-compete for an existing employee, it will be unenforceable for lack of consideration. In other words, we have a multitude of states that say that the agreement will not be enforceable unless you give a quid pro quo. and that continuation of the employment is not the quid pro quo. So you can't say, if you don't sign this, I'm going to fire you. If you sign it, I won't fire you, therefore it's enforceable in a bunch of states, and New York happens to be one of them. In New York, you must give separate consideration for the non-compete. So, for example, let's say we've had contracts every year with employees, and we didn't have the non-compete. Now we're going to write a new contract. We may change the provisions. For an employee, we may say, you're not getting 5 days of vacation, now you're going to get 7. Or we're going to raise your salary. And that constitutes the consideration for the non-compete. That is legal to do. And the law doesn't get into, in great detail, the sufficiency of the consideration. In other words, what did you get in return? I do not recommend giving somebody a 2-cent raise an hour, by the way. I think that really is pushing the limits here. But if you give a fair raise and you say yes, and in consideration of that, or health insurance benefits, or something of real value, that can be consideration for a non-compete. In other states, you can just give them the non-compete and have them sign it, and it's good as written without a dime. So again, you have to do this on a case-by-case basis. Certain states believe that parties are essentially equal. I proffer you a contract, you can sign or not sign. The business reality, though, for a lot of employees is that they're not equal. If I know that I'm in the Rust Belt and I have a job, and that there's an unemployment rate that's significant, and I'm over 50, basically if I don't sign it, I could be unemployed permanently. So that would not be equal bargaining power. When you're in other states where there are many more opportunities, then the considerations change. So the courts treat this differently. For example, Michigan actually allows continued employment to be consideration under many circumstances. Here's an interesting thing. What happens if the employer breaches a contract? So you have a contract with a non-compete and the employer breaches. Let's say you announce to the employer, I'm leaving, okay? And most states have wage theft prevention acts. The employer is required to pay you your final 2 weeks' pay. And the employer doesn't. The employer comes up with some cockamamie reason to withhold money from pay. Again, state by state this will vary, but in New York you can't withhold a penny. What I do in those cases, by the way, if somebody keeps a laptop or a phone, is I send them a 1099 for the full market value of a device that could be 5 or 10 years old and is really, ready to be junked, and they'll have to pay taxes on it, and that's the payback there. But if you have breached the contract, if you have violated its terms, generally you cannot now maintain an action against the other party for failing to perform. And that varies as to what the breach is and whether it releases the employee. We have different rules in different states, so I just wanted to point that out as well. What happens if you fire an employee in violation of their employment agreement? Assume that they have an agreement, it's good for 2 years, they've signed it, and you fire them. Some employees have said, you fired me, you didn't have cause to fire me, and therefore I think the covenant shouldn't apply to me. That it negated the consideration of continuing employment, for example. And the decisions on this are completely inconsistent. I think that's what you're going to hear a lot from me. I'm usually very rigorous in what I can tell you, but a lot of this is case by case. I have to also say, because we're dealing in state law, that there's a new rub. And that across the board in employment law, we are seeing municipalities write their own rules. New York City is probably the most famous, as well as Seattle, San Francisco. They are writing rules about employment relationships at the municipal ordinance level that go beyond what states do. So in every such case, we have to inquire whether in the larger municipalities and areas of the country that are likely to do this, do we have an override here? Are we having a state problem, a local problem to deal with in addition to the state law? So that can be quite a problem for us. Generally, the intellectual property, by the way, that is developed by someone while working for you. Let's say you're building a navigation system and you have an employee who actually does the building. Generally, you should have an agreement stating that any products or upgrades that are developed in the course of the employment on the employer's time remain the intellectual property of the employer and not of the developer. I do that all the time. In agreements, I was actually asked to review one the other day. Why do we need this? You need it. Every hospital that's involved in trying to seek a cure for cancer has now, in our area, retracted from agreements in which the doctors themselves can profit from this. There was a big scandal at Memorial Sloan Kettering about this recently that made us pay a lot of attention to the subject matter. So obviously we want to create enforceable non-competes. We want to enforce a non-compete without having to litigate unless we absolutely have to. And we also want to be very careful about hiring somebody who has a non-compete with a prior employer. So we have to be careful about our jurisdictions. So many of you who have contracts in the industry know that there's a provision called choice of laws. And it will say, if the master company, let's say, is located in Nevada, they want to be sued and to be able to sue in their home court, right? Not to have to go to another state in which they do business. So typically, if your state has laws that are favorable to you, you want that to be the choice of laws. If your state isn't so great, but the state in which the work is being performed is better, you might opt to do that. And then you want to say where a trial will take place. So I could say New York law, but my client happens to have operations in New York, but she's in Michigan. So I may say that any trial is going to take place in that county in Michigan. I sue on her behalf, and I sue a company or an individual who is based in New York. They're going to have to hire a lawyer in Michigan and get themselves out to Michigan in order to defend the lawsuit. And particularly when you're in the B2B situation, that can be a tremendous deterrent because we would have home court advantage. Also, to the extent that there is diversity of citizenship, you have a company based in Michigan and a company based in New York, for example, and we have a question of interpretation, and the amount in question is over $100,000. That's the potential loss. I can sue in federal court, which means I can do it myself. I don't have to hire a local lawyer in that jurisdiction. I can bring the lawsuit out there and be admitted to practice pro hoc vice without actually having an office in that state. So that's a further blessing for the client. So what do you do if your existing non-compete doesn't pass muster? Because remember, one decision, one person goes to court and wins. What you need to know is that's called res judicata. If that decision is upheld, it would affect every other contract you've ever written with that same clause, and that is risky business. That tells you maybe if I've lost on this basis or I have the potential for losing, I need to revise all my contracts and make the covenant lower, specifically to protect myself. If a non-compete is excessively onerous, to be honest with you, another company may pass and not want to do business with you. An individual may read this and say, I have to leave town if I leave my job with you, or if you fire me, you know what, I'd rather take something for less money. In employment, one of my favorite things to do, if there are real trade secrets, legitimate secrets that I need to have protected, I generally write what's called a garden leave provision. Now, this is not inexpensive, but it is very, very useful. And it basically cuts off the employee. So what it'll say is, we agree that your employment is going to end. I know that somebody in town is soliciting you. I don't want you to go. But on the other hand, you're not happy here anymore. You're not working the same way. You're sour. you might be potentially making insinuations to others, this isn't a good place to work. So very often in financial services, they'll have these garden clauses, and it'll say garden leave means leave to go gardening. So we're going to pay you 6 months of salary. You'll remain on the health insurance with all your benefits for 6 months or a year, during which we will change our trade secrets and our technology so that your knowledge will be pretty worthless. And at the end of that year, you are free to go to work anywhere. So the employee actually hasn't lost money. They're getting this lovely year to do, to go gardening, go swimming, go travel the world, but they can't harm us. And in return for that, we're actually paying them to do that. That happens not to be a bad thing to do. Another thing which I've mentioned already is having a liquidated damages clause. If you breach this contract and you try to compete or to solicit, it's going to cost you X dollars. Another thing that I like to do in drafting is to write in mandatory arbitration. So to backtrack a little bit about the U.S. Supreme Court, we received a ruling last year that says that mandatory arbitration clauses in agreements are enforceable, they are valid. So even though arbitration prevents you from going into the federal courts or the state courts, arbitration is a pretty rigorous process, and it doesn't deprive individuals of due process. It's just a little bit simplified, and the arbitrator is a neutral. So I write contracts all the time that say this will be governed by arbitration. I name the arbitration company, whether it's the American Arbitration Association or JAMS, or a smaller company, depending on the net worth of my client, in lieu of litigation. And what we now know is that those clauses can be enforceable and prohibit class arbitration. So if you look at the cases out in California in which individuals were suing this industry, claiming that they weren't independent contractors, they should be treated as employees, they should get time and a half and benefits and all those good things that I've lectured about before, you can write a clause saying that if you want to arbitrate, you have a grievance about this, you can only arbitrate as an individual. You can't bring along 1,000 other people all over the country who happen to work for the same company. There are conflicting schools of thought. I love those clauses. I think it puts a chilling effect on, and I think it's a good thing to do, because it prevents you from literally being taken out of business by a collective action. Now, some lawyers say, well, if you have a lot of employees and they each file to arbitrate, you were going to have 1,000 cases going at once, and that's going to be very costly for the employer. And so why not just let it be a class action? And at this point in time, with most of the clients I know in the industry, I would prefer to arbitrate. And generally, what I find in your industry is that everybody has their own unique set of facts. Each case, if you're dealing with a wage hour situation, the facts of how many hours you worked, overtime, whether the state requires an unpaid lunch hour, a paid lunch hour, or allows you to work straight through the day without any obligation to have that time off, it's going to differ state to state. And at that point, you're going to wind up with multiple litigations because the parties make different allegations, frankly. Another question in this is assignability. And for any of you who are thinking about selling your businesses, if you have a non-compete clause, it's very important to say this will inure to the benefit of anyone who acquires my company, the stock, the assets, etc., so that when you sell, the employee doesn't say, great, now I can do whatever I want. You want it to continue. And also, you always want the clause to continue past the survival of either the time limit in the agreement or of the employment. One thing I do to head off litigation is that as someone is leaving, I like to do an outboarding and to have the employer remind the employee, do you remember that 5 years ago when you came to work here, you signed a non-compete or a non-solicit? Oh yeah, I remember. Do you remember the terms of it? Not really. Do you know where you have it? It must be somewhere in the house. And what you do then is you hand them a copy of the agreement and say, just to refresh your recollection, here it is, read it, I'm going to repeat what it says, And then you can even try to get someone to sign a letter of continuing obligation. On my last day of work, I was provided with a copy. I had an opportunity to read it, and I understand that this is a continuing obligation. It's an extra piece of paper that can be used in litigation to your benefit. Another thing to do, if somebody leaves your employment and you have that suspicion, is run a forensic analysis on the computer, on the hard drive. Sometimes someone will download files, and you will find that out on their last day. And then you call them in and say, give them back. And if you don't return the files, then you're going to be in a legal proceeding. But if you fess up, no problem. Go in good health. And that's not a bad thing. That's not a bad thing to do. If you suspect that somebody is leaking information, conduct a full investigation. Consider how you can better monitor your electronic data. Now, social media can create a lot of problems. For example, I am asked all the time, my worker left and they went on LinkedIn, and of course a lot of my business contacts are on LinkedIn with this worker, and now she posts on LinkedIn, new job, and of course everybody gets it as one of these emails you want to delete 3 seconds later, but now it's out there. Is that a solicitation? In my opinion, updating where you are now in LinkedIn is not a solicitation. It's not evidence of competition. You're simply announcing to the world where you are and what you're doing there. What happens next could be a violation. If you are solicited, or someone comes to you and says, I'd like to do business with you, your answer may be, I'm at a competitor, I have a non-compete, it's good for a year, I'm so appreciative that you called me, we will be in touch in 12 months, all right? And I really hope that at that point, you will see what my new company has to offer, and perhaps do business with us. If you start seeing lots of emails or back and forth, hi, I'm going to be leaving. Just wanted to let you know, and I hope we can do business together. Here's my new contact information. I'll be calling you next Monday, my first day on the job. That doesn't look too good, and you can expect that the employer will find that out. And remember, if the employee tries to do what they think is so smart by deleting items after they forwarded them to themselves, a computer forensic guy with a minimal amount of training and expertise is going to find those. I've mentioned cease and desists. I also write letters in the cease and desist which will say, they're called spoliation letters. You are reminded that you may not destroy any documents that you may have lifted already. Don't think that you can put them in the fireplace and get away with that, because since I know you've done this, that's deemed to be spoliation, and an adverse inference can be drawn in a court. So in all of these cases, we are looking at the practicalities. How far can we go? How much will it cost us? What is the most expedient way of dealing with this situation? And I am called all the time by people who say, I want to sue, I need to sue. And I have to talk them off the ledge, because once you start litigation, getting out of it is very difficult and it's costly. And you can't assume that the other person's going to just, lay down and play dead immediately. They may fight back, or they have a new employer with significant resources who says, you know what, I can afford to fight this fight, and he can't afford to maintain the suit without diverting resources that should be used for business to pay lawyers. So that's an important thing. Temporary restraining orders and preliminary injunctions. It is, in our jurisdiction, it's difficult to get injunctive relief. As I said, the courts don't want to get involved in it. In other jurisdictions, they will give it like that. Case recently in Nassau Supreme involving a non-compete, the injunction, temporary restraining order was issued on day one. I was kind of shocked by why the judge did that. I think it's because she really likes that lawyer. But you have to show that your harm outweighs the harm to the other party, because otherwise the judges do not want to be policemen in these things. Keep in mind that if you sue for breach of a covenant, nothing stops the defendants from countersuing for something else. So even though you think you have a clean suit, other issues may be raised. For example, improper business practices to that point, and that can be a big problem. Even if, I just want to say, what if the new hire doesn't have a non-compete agreement, honestly does not have one? Be careful. Don't induce that person to go breach the fiduciary duty that was owed to the prior employer by running out and trying to take the clients away. Don't induce them or hint that if you come to work with me, I really want that client list or the pricing list. Don't elicit or ask for confidential information during a job interview. And so that's a pretty important thing. Sometimes you can negotiate with the old employer. So say the worker or the contractor has an offer and has a clause. Some employers or contract companies can be approached, and you can say to them, I know this worker has a non-compete. I would really like to hire them. You know what? What if I split the profits from that first year with you? Or what if I buy out the non-compete? What is it worth to you? Or you might make a list and say, look, I have clients on my list who you don't have on yours. There should be no problem with this individual working for those clients, but let's review. Tell me who your most important clients are. All right? Wells Fargo Bank. Fine. We will not engage with Wells Fargo Bank using this employee. You may say, I'm taking this employee has accepted an offer from me. I promise I'm not going to go poach other people from you, even if they approach me. In other words, even if the new employer isn't soliciting people from that company, we will not hire them. This law firm now has 88 lawyers. It started 5.5 years ago with 5. And many of us have come from other firms. And even though we're totally free to go, our partners have basically indicated to the rest of the legal world in this area that we're not looking to poach an entire practice group. We're not coming to people and saying, how much business can you bring in and you can come here. Everybody comes to this firm for different reasons, but it is not because we are poaching, even though we have a lot of flexibility, as I mentioned, in the legal system, because you don't want to get that kind of a reputation, frankly, in the community for doing that. So I want to talk a little bit about non-solicitation agreements. So I write non-solicitations all the time, and they are different from non-competes in a variety of ways. Some states that don't allow non-competes will allow the non-solicit. So the non-solicit prohibits the person leaving from them taking other people with them or inducing them to come along. It also means that the individual can't solicit the clients to follow as well. And so in a non-compete, we basically have a standard, let's say 1 year, you won't engage in a business. And by the way, that means either directly or indirectly, you can't be a consultant, you can't be a stockholder who's active in the company, a partner, an agent, an officer, associate, employee, contractor for any company engaged in the same business as my company. And then we should define what that business exactly is and the place. So obviously that all sounds good in general, but we go down to the details. Another thing that's typical in a non-compete is to say that the person who is leaving will not disparage the existing company, the original employer or B2B, to third parties, because that can have a tremendously deleterious effect. Non-solicits means I won't solicit business relationships, hiring people during a term of time. So obviously, it doesn't just mean employees. It means going after the contractors, because if they're contracting for that new entity or individual, that's time they can't work for you. So Interestingly enough, if you sell your business, that non-compete and non-solicit can be much longer than if it's employment. If I'm getting $1 million for my business and somebody wants to have a 5-year agreement that I can't compete or solicit in the area for that amount of time, well, I just got paid for that. There is value to that business. We're not going to enforce that when it's an individual who's on a salary or being paid an hourly rate. Territory, very, very different. If you are a small business in a small location, the territory needs to be small. Again, if you are regional, then we get into the dialogue about how much that means. If you, let's say you do business in Long Island and you do business in Rochester, New York. The fact that New York City is adjacent to Long Island, but you aren't doing any business there right now, generally, I would not find that covenant to be enforceable. Okay, you might be able to get a few miles into Queens if you're really doing business in Western Nassau County, which abuts Queens County. And if you're in Rochester, you might get a little bit broader area around Rochester. But if somebody wants to do business in Albany, that covenant is not going to be enforced because neither of you have been there before. As you can see, I have a lot of materials on this. Now, I happen to like severance agreements sometimes. Not for contractors because they're not your employees, but if you have an employee who is leaving and you want to basically have some bite, some consideration, it is not a bad idea to give them a severance agreement, and in the severance agreement you are paying them for an agreement not to compete. So if you do not have a non-compete now, all right, and you don't just suddenly want to hand people money, here's $500, sign a non-compete, it just makes you uncomfortable, or you have too many employees at play, it's going to be a lot of money for you. You can use a severance tool at the end of the day to say, I'm going to give you severance, but in return you have to agree to waive your rights. And you obviously have to have consideration here. So I'll just mention a couple of states are very hostile to the non-competes. Wisconsin hates them, for example. And so the courts get very strict about what's the interest worthy of protection, and they tend to be very narrow about that as we go on in time. Depending on your industry, the mileage restrictions can be very, very different. For example, in primary care medicine in Manhattan, if you put in a restriction of 20 blocks in any direction, that's probably going to be enforceable. In dentistry, statistically know that people don't go to the dentist maybe more than 10 blocks away. So depending on the medical specialty, we may see a different area of blocks. But it might be impossible to enforce a general dentistry, general ophthalmology restriction for all of Manhattan Island. Whereas if you were dealing with a unique specialty, it actually goes up. So the example I give is the corneal and retinal group on Long Island. That's their home base, but they cover the entire state of New York. They have something like 50 offices, from sea to shining sea, basically, in New York. And I should say sea to shining lake. Those are enforceable. People know when they go to work in that group that their intellectual property is so highly valued that if you leave, you need to leave the state. So, and they pay beautifully, but someone once tried to go into practice in competition with them far out on Long Island, and they were sued and shut down. So we really have to look at all of these things. Certain states will say you can only enforce the covenant as to the customers that were previously served, not the geography. Wisconsin's a good example of that. So you can see that this creates tremendous challenges for employers and for businesses in general in the industry. the fact that we do not have consistency, to me, is the greatest problem. We also have to recognize that there are two different dimensions. The dimension of signing a non-compete for the individual employee or contractor, and the second dimension is what's the state policy, what's going to happen after it's all signed and done when you try to enforce it. And that's an important reason, because some state laws, like California, Puerto Rico, for example, the law is very, very clear. In other states, we don't have that clarity of law, and we're not quite sure what's going to happen. Some states, Puerto Rico, if I remember correctly, has civil penalties due to the state if you overreach in a covenant. I also have to tell you, 40% of employees will turn down jobs at a competitor if there is a non-compete, even if it turns out that the non-compete is not enforceable. And that's, so it has a tremendous chilling effect. Do I advise people to write a non-compete knowing that it's unenforceable? Generally, I do not. And the reason I do not is because in the scope of any other type of litigation, it will not look good for the employer or the company to do something knowingly unenforceable in the jurisdiction. It's a good way to taint a judge against your client, because the judge will say, what are your business practices here? What are you up to? I don't like the fact that you wrote this, you had a lawyer write this, and it wasn't legal to begin with. So they will, I can tell you, 14 years as a judge, I could make a lot of decisions and I could justify them on paper beautifully. But what was going on in my head when I finally had to make the decision which way to go, if I had the flexibility, would be something like this. But I would never put it in the decision, because then I'm alluding to some outside issue. But it would, and so I'd be sure to justify my decision based on case law and interpretation and differentiating it from precedents to the contrary, but it would affect me. And you should know that judges are human beings and judges get affected. And if they think to themselves, oh my God, my son works for such and such company, and if he signed one of these, he'd be living in my basement if he couldn't get another job. It definitely will affect people here. This issue has a lot of effects on the labor market, and we know that that's happening. Right now, we have an administration that is very pro-employer. There is no doubt, whether you like this administration or you do not, the Department of Labor, and now it will be under the direction of Mr. Scalia, who is highly, highly competent. He's a brilliant lawyer. He obviously has a particular agenda, like his father, the late Justice Scalia, who, whether you liked his decisions or not, was a great legal scholar. There's no doubt that this is going to have an impact. We are going to see far more issues resolved in favor of employers. And here's the risk. If I go out on a limb on a contract and Joe Biden gets elected, or Kamala Harris from the unenforceable state, or, dare I say, Bernie Sanders, by executive order, a lot of stuff can get changed at the federal level and affect you. So I advise people to pretty much write politician neutral to be safe. I have seen more yo-yoing in every aspect of employment law in the last 5 years that I've practiced through the Obama and the Trump administrations. It leaves employers in limbo. Things that were legal yesterday may be improper or illegal today. And that's the case in misclassification, left and right. So you have to be fair in the way you think about this and not overreach enough, because it can really cause problems. So we are definitely in a time of potential reformation of the law. And yes, here's some, I'm going to give you some case law examples now. New York held in a case, a national non-compete is unenforceable. The employer only worked in 8 states. New York, when a company actually operated in the entire continental U.S., some courts have actually enforced that territorial restriction. The duration and the scope have to be tied to a legitimate interest. There is a case that got invalidated, a 6-month to 1-year covenant. Others have been upheld. This is that medical group I was telling you about, for 5 years. An employee's knowledge of the intricacies of the former employee's business operation is not a protectable interest sufficient to be able to enjoin the employee from utilizing his knowledge and talents. But where an employee services are not extraordinary or unique, covenants are enforceable, but only to the necessary extent to prevent the employee from using or disclosing trade secrets, processes, or formulae, or soliciting or disclosing any information about the customers. So now we have a limited standard. Uniqueness. What if we have a unique employee? And so we complain because he's unique, our risk becomes much higher. Well, what do we have that's really unique? Working in a highly specialized field with a small potential pool of clients, where that employee's success depended on the ability to procure and maintain client relationships, and the plaintiff was able to show with competent evidence that they had expended a lot of time, money, and effort to cultivate the special relationship. Somebody who goes out to do a field inspection for you does not have a special relationship with anybody, frankly. If you deal in the biotech industry and someone is part of a consortium between Harvard and Stanford and the NIH and soliciting private investors to this, that is potentially the unique relationship. So where you have just run-of-the-mill employees or contractors, we're going to have much more trouble finding uniqueness. And as you go up the food chain, you get to the regional level and the national level, clearly we have a cadre of individuals who work in this industry who are highly specialized, highly experienced, highly trained, and highly knowledgeable. And the covenants may work against them in many, many states. If you have someone who founded a company, who created a process, and then they ultimately leave, you can imagine that the confidentiality and non-compete clauses are going to be viewed with much more strength, again, than somebody who is much lower in the company. So believe it or not, in New York, there are 9 different cases that somebody can bring for a non-compete violation. Breach of contract, if you have a written contract. The breach of the duty of loyalty. Tortious interference with contract. Everyone talks about tortious interference. It's actually difficult to prove, I will tell you, unless you have really good fact patterns. Tortious interference with a prospective advantage. Unjust enrichment. Conversion, and that's a civil way of saying stealing. Defamation. Aiding and abetting a breach of contract or a breach of loyalty. And finally, unfair competition. Those are just 9 potential causes of action. What's interesting is that other than the breach of contract, and defamation is very difficult to prove, other than the breach, all of these talk about equity. So we have torts and we have contracts. Equity is torts. And equity is very difficult to prove. We used to say in law school that equity is everything that's not a contract. Well, it's more like a Nerf ball, and a contract is like a steel pipe. So if it's mushy, it's harder to prove. It becomes a lot of he said, she said, conjecture. Well, clearly that would imply X, Y, and Z. Maybe clearly to you, but not clearly to a jury. So that becomes much, much harder, because in litigation, the goal is to recover money, essentially. And so in order for a jury or a judge to calculate what's due, it's a lot easier to do it based on a contract. You read the contract, you read the terms, you obtain financial information, and you run the metrics. In a tort, well, I might be losing so much going forward in profit. It's a guessing game. And that's not an easy thing to do. It makes the litigation also much more complicated and lengthy, and it makes the risk of losing all that much higher. So that can be really, really a difficulty for people to deal with. And it's an interesting area of law to practice in because it's not static. It changes all the time. But there are economists now who are actually doing studies of all of this as to competition. And you know, every study says something different. I don't think we can draw any conclusions here. What I do know is that in your industry in particular, which is very siloed, top down, as opposed to what they used to call in antitrust law the horizontal integration of different pieces of business. When you're in a silo, the potential risks for breach become much, much higher to you. And frankly, there are ways to deal with this, in my opinion, and I'm just going to tell you my opinion, you may disagree. There are ways to deal with this that I think are collaborative between the different tiers of this industry. I know that hasn't happened to a significant extent to this point, but I would all encourage you to engage in collaborative dialogues to evaluate how best to engage up and down the chain with your cohort groups in order to mutually protect one another. Recently, I wrote an agreement for a client in which we directed it not to the employee who was leaving or the contractor, but we directed it actually to the national, from the regional up to the national, in which the national said, in consideration of services that you provide and the contract that we are signing at this time, so we had a new contract, we understand the consequences of a solicitation or going under you down to the local, and we agree not to do it because we think that's bad for the industry, we think it's bad for our relationship, and we want to cement the relationship. And I think that's a relatively new thing to do in the industry, but it's something certainly worth considering. So I hope you have a wonderful time in Dallas. I'm so jealous that I won't be there. I wish you all the success in your businesses and that you enjoy the remainder of the summer. I thank you for putting up with me and listening to me for this protracted period of time. If any of you have questions for me, I believe that NAMFS will post my contact information so that you can reach out to me. And it would be my pleasure to speak to any of you personally. And thank you again for listening.